is Deaver versus Wells Fargo Bank.
Yes, sir. May it please the court. I'm Richard Stadler. I work with the law firm of Darby, Peel, Crafts, Green, and Stadler from Lake City. And I am here representing the defendants in the lower court, which were the former property owners, the Cornelius and Assunta Deaver. Mr. and Ms. Deaver, as I said, owned the piece of property that we're talking about. This case originally arose as a foreclosure, although at this point it's a dispute between the property owners and a junior lien holder over the surplus funds from the foreclosure sale. The foreclosure sale in this case was held on April 25th of 2012, and it resulted in a surplus, which was what we're here arguing about today, of about $86,000, which money was held by the clerk. This appeal focuses entirely on that single issue of who's entitled to those surplus funds between my clients and one of the other defendants in the case, which is a subordinate lien holder, Wells Fargo. So the plaintiff's really not involved anymore in the case. I think the facts in this case are pretty straightforward. The Wells Fargo did not file a post-judgment claim for the funds within the 60-day period that we believe is provided for both by rule and by statute. The claim that they filed, the sale was in April of 2012 when they actually filed a motion requesting the money, and a proof of the claim of their entitlement to the money was in April of 2013, almost a year later. I had filed on behalf of my clients sometime in November of 2012, well after the 60-day period had expired as well. Now, despite the fact that they didn't file this claim within the 60 days, and I'm going to come back and talk about that in a second, the lower court awarded the funds entirely to Wells Fargo. That's the award that we're appealing here, is the order that order awarding the funds to Wells Fargo, and we believe that it should be reversed because we don't think the judge followed the trial judge followed the correct law below. 45.031, and the legislature changed the statute a couple of years ago. And 45.031 is the provision that requires a foreclosure judgment to contain, and this foreclosure judgment contained what I think is clear and unambiguous language that says, if you're a subordinate lien holder, which they were, claiming a right to funds remaining after the sale, you must file a claim with the clerk no later than 60 days after the sale. If you fail to file a claim, you will not be entitled to any remaining funds. The Florida Supreme Court adopted that exact identical language in Rule 1.996, that's just the foreclosure form. And the enabling portion is contained in Florida Statute 45.032, which changed existing case law, which had created a presumption in favor of the junior lien holders and created a presumption now that arises by legislative act in favor of the record owner, subject only to subordinate lien holders who timely file a claim. And that's in 45.032.
Let me ask you a question about,
yes, sir.
About the statute. The statute in Section 3 has a form, the owner's claim for mortgage foreclosure surplus. And Section 2 of the form that the owner is supposed to use to file a claim says, we do not owe any money on any mortgage on the property that was foreclosed other than the one that was paid off by the foreclosure. So if that language is in the form that the owner is supposed to use for filing a claim to the surplus, doesn't that suggest that if they do owe money on another mortgage, there's a problem?
I don't believe so. I believe that the intent of that, and if you read that, and I think counsel and I agreed before you came back in that the legislature didn't really consult any attorneys in writing this statute, but it's not the clearest. But if you follow their scheme, if the property owner files a claim during the first 60 days, the clerk is supposed to hold the money for 60 days to wait for claims. If the property owner files during that 60 days, he's required to report whether there's anybody else that he owes money to on that claim form. And then
why report that if it doesn't matter if the other lien holder hasn't filed a claim?
Well, again, I don't think it matters. I mean, my client indicated that there were other mortgages on the property. He didn't deny that. It's just that they hadn't filed their claim and they weren't entitled to the funds. I mean, I understand what you're asking me, and it's in the affidavit, but in the motion that we filed, we didn't deny that there were other existing mortgages on the property, but their 60 days had expired. If it doesn't say in there that the clerk is to pay the amount that's shown in the affidavit, it just says, during the 60 days, you pay whatever claims are filed, and at the end of the 60 days, the rest of the money goes to the owner. If you don't know who the owner is, the sole job then is to appoint a surplus trustee whose sole purpose is to find that owner. He doesn't try to locate the lien holders. There's no provision at all to locate the lien holders that haven't filed. They're gone. They're out of the picture at that point. They have no further interest in the case. They were all parties. They were joined in the lawsuit. They had notice. They got a copy of the final judgment. They would have had ample opportunity to read the judgment and know they needed to file their claim. And filing a claim for a lien holder is important. And it's more than just a prayer for relief in your original complaint, because a lien is nothing more than a lien. And the amount that's due on that lien cannot be determined by looking at the lien. Okay? So there has to be something filed, just like there is with the plaintiff in a mortgage foreclosure. There has to be some proof filed for them to be entitled to payment. And that, I think, is what the legislature is talking about when they say to file a claim. At some point, they're going to say, it was an unsatisfied mortgage, there's this amount that's due and owing in principal and interest, there's whatever that they can establish. The mortgage could be paid down to $10. It could be paid down to $100. It could be an unsatisfied mortgage. The public records are full of unsatisfied mortgages that have been paid. They've never been satisfied of record. They get joined in mortgage foreclosures for because they're trying to clear the title to them. There are all of those issues, which is why something has to be done by that lien holder to file. And that's what the legislature seemed to be saying, is you've got to file within those 60 days. I have questioned myself, in fairness to you, I've questioned myself why that's even in there, because it doesn't seem to have any meaning in their statutory scheme of the importance of how they pay it. I mean, they pay the claim that the lien holder files, they pay the balance to the owner. It doesn't seem to matter what the owner puts down there if he owes other people money. So, in this particular case, they did not file that claim.
Mr. Statler, can I
Yes,
interject?
ma'am.
I think our court has addressed this very exact issue on June 6th last week. The case of Matthew versus Branch Banking and Trust Company. I don't know if either of you, I've checked to see if either of you have filed a notice of supplemental authority, but basically Judge Casanueva authored the opinion, and let me give you the citation.
Sure.
It's a 2014 Westlaw 2536831. And Judge Casanueva, along with Judge Davis and Judge Northcutt, seemed to rule that basically the language of section 45031(7)B is clear and ambiguous. It basically indicates that because it's so clear and it's so ambiguous, that because the bank, in that case was BB&T, did not file a claim within 60 days of the sale, they were not entitled to the surplus. And obviously
I did not see that, and we pulled the case yesterday, and for some reason it didn't pop up when I pulled the statute again, which is what I usually do, is hit the statute. We were talking this morning.
It's a very recent case.
Yeah.
And it seems to be exactly similar to the facts of this case. And so I don't know whether or not
I did not. I appreciate you bringing it to my attention. That's our position is, it's clear, it's unambiguous, you've got to file something within 60 days. If you don't file, I think the money would belong to the property owner under the presumption that the legislature created, and we think that because of that, the lower court committed error in awarding the funds to the lien holder who did not file that claim within the 60 days.
How about the argument, and I know counsel hasn't mentioned that, but I've noticed even this case, one of the things that counsel indicates that your client was late also in filing, within even your clients did not do a claim within the 60 days as well.
Correct.
And whether that becomes an issue, but quite frankly, in the Matthew case, both people were late as well. So I think that becomes...
Well, I mean, if nobody files a claim within the 60 days, the statute says what the clerk's supposed to do. They appoint a surplus trustee, and that person's sole job is to find the owner. They don't look for lien holders, nobody else. They find the owner. When the owner's found, the clerk pays the money, surplus trustee gets his fee, and the clerk pays the money to the owner, period. And that is the scheme that's set forth. So I don't know that there's an obligation on the property owner to file within the 60 days because the money is his if nobody else files within the 60 days.
And you think in our case here, because the court conducted an evidentiary hearing, somehow that takes it away from the statute?
Well, I don't think there should have been an evidentiary hearing, but there was no, the transcripts were presented. There was no evidence presented because the facts were not in dispute. What the judge ruled was that the trial court ruled is that because they had pled, they had a prayer for relief in their answer to the complaint where they prayed for the surplus funds, that somehow excused them from having to file. I guess she treated that as a claim. And I was cited to the Diaz case, which this court decided on interpretation of the rule that says you have to file attorney fees post-judgment within 30 days, which is a very similar thing. You have to file post-judgment. And same argument was made in Diaz. Well, we pled it, so we shouldn't be obligated to that. And this court said that it's not that the rule is not self-effectuating, that you've got to file something post-judgment. And I think the same argument would apply there, that I don't think the fact that you prayed for it, it wouldn't, first off, praying for it wouldn't give you entitlement to it until you submit the claim and show the amount.
And the Matthews case again, that's
Dealt
the
with
same
it.
thing. The language here, it says the trial court ruled that BB&T had asserted its claim to any surplus funds and the answer in affirmative defenses, which was filed well before, obviously, the foreclosure sale. And what our court said, we conclude that the trial court erred in interpreting the mandatory claim provisions in Chapter 45 to mean that an answer in affirmative defenses filed in the civil lawsuit satisfied the requirement that the party filed a claim with the clerk after the sale of the property.
I think I agree 100% with that case, Your Honor.
Really? What a surprise that is.
All right, thank you, Mr. Stanley.
And I do apologize for not having found that. I do apologize.
It's a very recent case.
We've been waiting for one, so.
No need to apologize.
Good morning, Your Honors. Todd Armbruster appearing on behalf of the Appellate Wells Fargo Bank. I have not obviously had an opportunity to review Matthew, but I would point out one distinguishing characteristic in this case from the Matthew case, granted, having not read it and just having heard about it today.
Let me just say this. We realize you haven't read it and you haven't had a chance to address it. If you would like, I would give you 7 days to file any supplemental submission that you wish.
I would appreciate that, Your Honor. Yes.
And Mr. Stadler, same to you. Not another 7 days. If you want to submit anything within the 7 days to address that case, we'll let you do that.
Okay.
That's very fair, Your Honor. Thank you.
Going back for a moment, though, I think there is a distinguishing characteristic between these cases, again, not having obviously read the Matthews opinion. This statute that we're operating under, the pertinent provision is 45.032 subsection 3. And what that statute does is it sets forth 3 different scenarios for which surplus proceeds are to be handled. Scenario number 1 is where the property owner makes a claim, there are no subordinate lien holders, and the statute's clear and unambiguous. Property owner gets the money. The second scenario is a situation where there is a subordinate lien holder that makes a claim, or, and I think this is important in the alternative, the property owners acknowledge that there is somebody else out there that may have an interest in the surplus proceeds. If that situation occurs, the statute is again clear and unambiguous. There has to be an evidentiary hearing. What I didn't hear when you described Matthews was whether or not the property owners acknowledged that there was somebody else out there that may have an interest in the surplus proceeds. In this case, they did. First of all, as counsel commendably acknowledged, his motion acknowledged there were junior lien holders. Number 2, they were defaulted. And by virtue of the default that was entered against them in the foreclosure proceeding, they admitted all well-pled allegations in the complaint, including the allegation that Wells Fargo held 2 junior mortgages against this property. accepting what Matthews says in terms of a claim cannot be filed as part of an answer, and respectfully I disagree with that, and I think there are some cases that I can cite to that address this point. But accepting the Matthews decision as it was described, what counsel has not addressed either today in oral argument or in any of the briefs is the concept of why was the evidentiary hearing not proper when his clients admitted, acknowledged, Wells Fargo is out there. Wells Fargo holds 2 junior mortgage liens against this property. The law tells us, and again, this is clear and unambiguous, 45.032 subsection 3, that when that occurs, the trial court was required to hold the evidentiary hearing. The language says shall hold an evidentiary hearing. That is why when the judge heard about all of this in June, she set the evidentiary hearing in October. At that hearing, the only evidence presented was the affidavit of Wells Fargo, where it averred we still are owed $134,000 on the second mortgage lien. There's only $86,000 that's sitting in the court registry. We're entitled to it. And so, again, not having read Matthews, and I don't know whether there was a default entered in that case, and I don't know if there was other acknowledgments made by the property owners, but in this case there was. And because of that, I think Matthews is distinguishable. Now, the other thing that I would point out is that the Third District Court of Appeal actually addressed a somewhat similar circumstance in a case called National Equity Recovery Services versus Williams, which is at 962 Southern 2nd, 977. And in that case, someone other than the property owner filed a premature claim for surplus proceeds. They filed the claim before the certificate of disbursements was issued. And based upon that, the trial court said, I'm giving the money to the property owner. The Third District Court of Appeal reversed. The Third District Court of Appeal found that that claim, which was filed before the certificate of disbursements was issued, was valid. And it remanded with instructions to conduct the evidentiary hearing. And it went on to say that if at that evidentiary hearing evidence was presented that justified giving the monies to this other person, they should be given those monies. So I think at least one other of the district courts has addressed a similar type of issue. I would also point out, and I know this was a PCA, but this court in the case of Verrazano versus Suncoast Schools Federal Credit Union, which was a 2014 Westlaw 889060, and I think it was in March of this year, addressed an identical set of circumstances. It was a dispute between...
I understand that that's not precedent.
I completely understand, Your Honor. I'm just pointing out that certainly this is an issue that's been percolating. Certainly there are other circumstances with identical facts where orders dispersing the funds to junior lien holders in these situations have been affirmed. And I know that there's not precedent. I know there could be a completely different panel. I know there could be other extenuating circumstances. But it is another situation where there was an affirmance of a similar type of circumstances. So given all of that, given the distinguishing characteristic that I just pointed out between this case and Matthews, where there was an acknowledgement by the property owners that there was a junior lien holder, I think the lower court was infinitely correct and completely followed the statute when she said we have to have an evidentiary hearing. And based upon that, even again accepting that Matthews says exactly what's been represented here today by the panel, I still think that the trial court was correct conducting the evidentiary hearing, and based on the undisputed evidence, and again, they don't dispute that there was a loan, they don't dispute that the banks owed $134,000 on that loan. They're just simply saying, you know, you didn't file in that narrow window, so you lose.
Well, you know what's interesting? I'm trying to find an analogy. After I read this case, and this case from our court basis said you have to file a claim. Then try to think of, I guess, a similar analogy. It would be almost like a request for attorney's fees, you know, based on the case law. Mm-hmm. When you file a complaint or you file anything, you make a request for attorney's fees, but later on, you have to file a motion in order to claim this is what you're entitled to and so forth. So is it similar to that, okay, you've raised it in your answer in affirmative defenses, but now we're dealing with the statute, you must file a claim. And I'm looking forward to really, and I'm glad Judge Wallace has extended to you all the opportunity to submit supplemental briefing, because the Matthews case simply say this is clear and ambiguous. We're bound by the mandatory, you know, statement that it shall file a claim.
Well, I think there, and counsel made a similar analogy to a Rule 1.525 motion in his briefs, and I think there's a very significant distinguishing characteristic. When you file a claim for fees in a pleading, as this court pointed out in Diaz, it's not self-effectuating. There has to be additional activity thereafter. After the judgment's entered, you then have to file a motion and proffer evidence. As this statute is written, 45.032 subsection 3, a claim is self-effectuating. And what I mean by that is it says that once a claim is filed, the trial court shall set that evidentiary hearing. So to me, the better analogy is actually to Rule 1.440, where it says when you file a notice of readiness for trial, the ball is now in the lower court, and they have an obligation to then set that hearing. So unlike with a fee motion, where if just because you claim it, nothing else is going to happen, the court's not required to act, in this situation, the court is required to act. The statute says once that claim is filed, you shall set an evidentiary hearing. You shall take evidence. You shall make a determination as to who is entitled to those funds. So I think there's a dramatic difference between a fee motion and a claim. The other thing that I would point out is claim is not defined anywhere in this statute. Counsel suggests we have to file evidence and certain things. It's not defined. There's nothing within the statute that says you can't raise a claim and an answer. There's nothing that says you can't raise it, frankly, in any form. Unlike, for example, with, as Judge Wallace pointed out, with the property owner, there's a form that they created in the statute for the property owner. There is no such form for a junior lien holder. So given the lack of a definition, the concept that just because a bank files a claim in an answer, that's somehow ineffective unless the bank restates the claim within that narrow 60-day window, frankly, to me, doesn't make any sense. The other thing is that the language that the legislature has mandated be in these judgments says no later than 60 days. The Florida Supreme Court has interpreted the term no later than to be a deadline, not creating a window. It creates a deadline. And it did that, bear with me for a second, in the case of Barco versus School Board of Pinellas County, which is 975 Southern 2nd 1116. And it said no later than implies only a fixed end. So we've created a statute that says no later than, which means that that's simply a deadline. And there's no question that Wells Fargo met that deadline. I mean, they filed their answer more than a year before the sale was conducted. Given that, and again, I haven't had the opportunity to read Matthews, and I'm not really sure what language they're seizing on that is so allegedly clear and unambiguous. When I see no later than, to me, that is anything but clear and unambiguous. It, to me, denotes a deadline, as the Florida Supreme Court has indicated. We have a statute that doesn't define claim. We've certainly made a claim in the answer. We've said, hey, for a junior lien holder, we're entitled to the surplus monies. And then we have a statute that says once that sort of a claim is made and you stand up and say, hey, I'm entitled to the surplus funds, and you meet that deadline, you're entitled to an evidentiary hearing. I'm at a little bit of a loss as to where this judge went awry. To me, she completely followed the statute as written. And again, I keep going back to the concept, and I think it is critically important in this case, that they acknowledge that Wells Fargo is a junior lien holder. The 60-day window is an interesting academic concept, but I would suggest to this court, respectfully, it's a bit of a red herring argument in this case, because if they've acknowledged Wells Fargo as a junior lien holder, they've acknowledged it in their motion for the surplus funds, they were defaulted by virtue of that default, acknowledge Wells Fargo as a junior lien holder, we don't even need to file a claim. The law says, the statute says, that when they acknowledge it, we have that evidentiary hearing. And when that evidentiary hearing is conducted, that's when we have to come forward with our evidence. And we did. And so based on that, again, I think Matthews is completely distinguishable. I will certainly enjoy reading it. I will brief it. But ultimately, at the end of the day, unless it goes beyond that and says that an acknowledgement is somehow nullified by a failure to file a claim, I still think that the lower court was correct, and we would ask that this court affirm its order. Thank you.
All right, thank you. Any rebuttal, Mr. Sadler?
Just very briefly, Your Honor. In section 45.0323 that was referred to for the evidentiary hearing, clearly says if the owner files a claim within the 60-day period. and says there's a junior lien holder, then you hold an evidentiary hearing. Subparagraph 4 says if no claim is filed during the 60-day period, the clerk appoints a surplus trustee who locates the owner, and the clerk pays the money to the owner. That is for the limited situation where the property owner files in the first 60 days, and I assume that would be in a scenario, for example, you owe a condo lien, so there's $30,000 in surplus. We admit we owe them 10. We don't want to wait for the period to run, so we'll file our claim and we say we owe them. And then if there's a dispute between the two amounts, the judge sets an evidentiary hearing, but it's only during that 60-day window, and that's what the statute says. And so we don't think there's any, I mean, again, I don't think there was any basis for this court to hold. There was no claim filed until 8 months after the sale, so it wasn't within the 60-day window. Thank you.
All right, what I'll do, we'll entertain submissions, supplemental submissions that are directed to this new case to be filed within 7 days, not to exceed 15 pages. Assume that'll be sufficient.
I'm sorry?
I said, I assume that will be sufficient, 15 pages.
Oh, yeah, I'm sure.
All right.
I don't think my brief was that long, so I'm sure that'll be close.
Thank you both.